Hi, and welcome to session number 11 in our Human Resources Management series. I'm Charlie Domville-Lewis, Senior Education Officer at the Department of Commerce at the Labour Relations Division. Now, over the past couple of months, we've been looking at all the different kinds of areas of employment law that you need to be aware of as an employer. So your rights, your obligations, different entitlements, and different areas of employment to be aware of. Today, we're going to be looking at the end of employment. We're going to be looking at termination, dismissal, and a little bit about the performance management process, i.e. how do you try and sort these problems out before they become something that you need to terminate someone for. So in terms of what we're going to look at the different kinds of termination. So we're going to look at unlawful, unfair, and also what happens when someone conducts serious misconduct. So we're going to basically be looking at the ways that you can get in trouble in terms of dismissing someone. We're going to be looking at what could constitute a fair or valid reason to terminate someone. We're going to be looking at what's called procedural fairness, which is the steps you've got to follow before you terminate someone. We're going to be looking at who's excluded from making an unfair dismissal claim and the timeframes that an employee has to make those claims. Finally, we're going to look at the outcomes. So in the worst case scenario, someone takes you for unfair dismissal and they're successful. What happens then? We're going to look at the notice periods. So this is the period of time that you have to offer an employee to continue working for you if you terminate them, and also the period that they have to offer you if they want to leave termination. And then finally, we're going to have a bit of a summing up and looking at what performance management is, why it's important, and how you might want to do it. So firstly, we're going to look at unlawful dismissal. So this is one area of employment law where you can get in trouble for terminating someone. This is when someone is dismissed on what's called prohibited grounds. So if someone is dismissed on any of the areas that we're looking at here, if someone's terminated because of their age, their race, their gender, their religion. Now that says absence from work. That's sort of misleading. What we're looking at there is absence from work for a legitimate illness or injury that they can prove that they had. Someone can't be also terminated because of union membership or for not being a member of a union. And a really important one that a lot of people don't realize is someone cannot be terminated for lodging a complaint with Wageline or the Fair Work Australia. It's really important to realize that if someone is checking on their rate of pay and they find or they believe that you're not paying them correctly, if they then tell you that, you cannot terminate them for that. It's called a workplace right. Someone cannot be terminated for exercising a workplace right, and this is their right to check on their rate of pay and make sure that you are actually paying them that. So unlawful dismissal is one area where an employer can get in trouble. What's more likely, or what's more common at least, is someone is going to make a claim for unfair dismissal. Now this relates to two areas. It has to relate to a fair and valid reason for someone's termination, and it relates to the procedure that someone follows, an employer follows, in terms of terminating that employee. So for it to be a fair and valid reason, it has to relate to one of three areas: someone's capacity, someone's conduct, and the operational requirements of the business. So what does that actually mean? Well, capacity is pretty self-explanatory. Can this employee do the job that you've hired them to do, and can they do it to the standard that you require? That's essentially what a capacity issue is. Conduct is a lot broader. Conduct relates to a raft of areas, but essentially it's someone's behavior in the workplace. Now that can relate to how they treat fellow employees, how they treat clients of the business, how they treat the employer themselves. But also it can relate to things like the workplace's policies. Does someone comply with your safety policy? Does someone comply with your use of internet policy? Does someone comply with your policy on other resources that the business provides? Those are all areas that could come back to someone's conduct in the workplace. So it's a lot broader in terms of what could be considered a conduct reason to terminate someone. Finally, we've got operational requirements. Now, operational requirements, that's separate to capacity and conduct. Operational requirements don't really relate to the performance or the behavior of the employee. It comes back to the business. It comes back to money. If a business is struggling, if it's losing money and has to terminate employees to stay afloat and stay viable as a business, that could be considered a fair reason to terminate someone. If it introduces technology that replaces someone's job, again, that could be considered a fair reason to terminate someone. But when you have operational requirements as the reason for someone's termination, generally they will be entitled to some kind of severance or redundancy payment. Now I won't go into that too much because there's a lot of different factors that affect whether someone receives redundancy or severance payment, but it's something to be aware of if that's the reason that you're terminating someone. Essentially, with operational requirements, someone's job is disappearing entirely and no one's going to replace them. They're not being replaced at the end of their employment. It's the end of that job. So it's different, as I say, to capacity and conduct, which is a performance issue. It's something that's actually wrong with the employment or the employee's performance or their behavior. Now, when we have issues with capacity and conduct, there's another area that you have to look at, and that's called procedural fairness. This is the procedure you have to follow if an employee is having issues with capacity or conduct. So you cannot instantly dismiss someone for these issues. You have to let them know that there's a problem, you have to give them a time frame for improvement, and you have to let them know that they could be terminated if they don't sort that issue out. So there's this wrong with your work. You're being consistently late to work every day. We want to see this sorted out by the end of next week. Also, you have to give them a chance to respond. So you have to let them explain why they might have that issue. Then you have to give them a time frame to sort it out, and then let them know if they cannot sort that issue out, they may be terminated at the end of that. That's basically the steps you've got to follow. A lot of people think you have to provide 3 written warnings for any issue. That's actually a bit of a myth. That's not something that is a legal requirement. A lot of bigger companies do it because it is a good way of fulfilling procedural fairness. And I'd recommend that if you can sort it out that way, that might not be a bad way to do it, because if someone does make an unfair dismissal claim, it's good to have those 3 recorded written warnings to show that you did try and sort out that issue, and that you gave them a time frame, and that you let them know that they could be terminated for those issues. All right, let's look at an area that comes up a lot, and an area that will actually invalidate areas like procedural fairness and a fair and valid reason. And this is what we call serious misconduct. This is something that an employee does that is so bad, essentially the employer could not be reasonably required to keep that employee on after they've found out this has happened. So this is serious areas such as theft from the business, harassment or violence towards the employer or to other employees or to clients of the business. Fraud, so that could be, say, pretending that you have qualifications that you don't actually have, or pretending that you've done work that you haven't actually done. Or areas like consumption of drugs or alcohol while working. Whether that, so that could come back to someone's work safety performance, whether someone is complying with work safety. And it's the employer's obviously obligation to make sure that they provide a safe workplace. And if someone is intoxicated in that workplace, it could compromise that. With any of these areas, potentially the employer can instantly dismiss an employee. So they haven't got to provide notice, they haven't got to provide warnings, they can tell someone to leave as soon as they've found out that this is the issue. One thing that we would say is have a plan in place, because often a serious misconduct issue is going to result in quite an ugly, can result in an ugly scene in terms of terminating someone. Also, if the areas of the allegations, for example, are theft or fraud, it's not a bad idea to advise the police of this. You don't have to necessarily press charges, but it's not a bad idea to report it to the police to show how serious this issue actually is. The other thing that I would advise is that if you are intending to terminate someone for serious misconduct, to get some advice and be sure that it does actually qualify as serious misconduct, and that it's not just a capacity or a conduct issue that you could actually performance manage and sort out before they terminate them. Also, we would say that if it is serious misconduct, that you do actually instantly dismiss them, because sometimes if someone is allowed to continue on after serious misconduct, you can't then argue that it's something that necessitates an instant dismissal if you don't do it straight away. All right, now we're going to look at some of the areas that exclude someone from unfair dismissal. Now, with all these areas, it's not a hard and fast rule, but it does count against an employee in terms of making an unfair dismissal claim. Because other than these areas, you have to be aware that no matter how good your system in place is, nothing can really prevent an employee making an unfair dismissal claim. All you can do as an employer is make sure that you've got enough evidence to show that you did actually do everything that you could to sort out the issue before you terminated them. However, these areas are excluded from making unfair dismissal claims. Anyone who earns in excess of $134,100 per year cannot make an unfair dismissal claim. Well, that's not actually true. They can, but they can't do it through the government. They have to hire a lawyer and do it civilly and do it off their own bat, but they can't do it through the government systems in place. An employee that's on a fixed-term contract. Now that actually needs to be clarified to say that someone who reaches the end of their fixed-term contract. That's because in a fixed-term contract, the end of the employment relationship is built into the beginning of the relationship. So there's no grounds to argue that you are unfairly dismissed. If someone's dismissed during the terms of their fixed-term contract, then maybe they can make an unfair dismissal claim. And finally, a probationary employee. Now, most awards at least, will provide for a 3 to 6 month period where someone is on probation. And during that time, they are being assessed as to whether they are good enough to do the job and whether they have the skills and capacities necessary. Now, during that time, if someone's dismissed, once again, that doesn't necessarily make it impossible for them to make an unfair dismissal claim, but it's a factor that will not count in their favour if they do take it to the Fair Work Commission or the Western Australian Industrial Relations Commission to make a claim from the fair dismissal. If they're in their probationary period, that is something that would be counting against them in terms of making a claim. All right, let's now look at outcomes. So worst case scenario, someone takes you for unfair dismissal and they're successful. What actually happens then? Well, there are 3 things that the courts look to do, and this is the order in which they look to do them. Firstly, reinstatement. So they actually look to put the employee back in the position that they were in before they were terminated. Now, in most cases, that's not practical because obviously the relationship is soured to the point where someone's been unfairly dismissed and they've made a claim for it. So most likely what they will look to do is re-employ someone. That means that they put them back in another position on a different supervision, but at the same company. If neither of those options are available, then they look at compensation. Now that's basically what they look at there is what has the employee missed out on as a result of being terminated. So what money have they missed out on because of that? They might also look at deterrence. Sometimes in a business, if the business's conduct in an unfair dismissal case was particularly bad, particularly unlawful, and particularly, I guess, immoral, and a judge may look at setting a higher rate of compensation as a deterrent to say we will not tolerate this kind of behavior from employers. However, that will max out at 6 months' salary. That is the most that an employer can ever be expected to pay in terms of compensation for an unfair dismissal claim. And from my perspective, I've never seen it go that high, but that's the max that it can be. All right, we're going to look now a bit about the timeframes that an employee has to make a claim for unfair and unlawful dismissal. Now, it's different from the state and national system in terms of unfair dismissal. In the state system, an employee has 28 days to make a claim for unfair dismissal. When I say 28 days, I'm talking about calendar days, and that's true of all these timeframes. So basically, we're looking at 20 working days to make a claim for unfair dismissal in the state system. In the national system, they have 21 days, which essentially is 15 working days. For unlawful dismissal, they have 60 days in both systems. So now that's going back to dismissal on basically discriminatory grounds. If someone believes that they've been terminated solely because of their gender, their family responsibility, their race, their gender preference, or any of the areas that you can't terminate someone for, they have 60 days to make a claim for that, regardless of what system they're in. All right, now moving away from unfair and unlawful dismissal, now let's just look at a lawful termination and how much notice you have to provide in that case. So an employee must be provided notice as per the Fair Work Act of 2009. So if an employee has been working for not more than 1 year, they get at least 1 week of notice. If it's between 1 and 3 years, it's at least 2 weeks notice. Between 3 and 5 years is 3 weeks notice, and then any more than 5 years is at least 4 weeks notice. One thing that you need to be aware of though is if the employee is over 45 and has worked for at least 2 years, they then get an extra week on top of that. Another area to be aware of is that you can pay a staff member rather than have them work that notice. A common argument that we hear from employers, which I think is fairly reasonable, is I've just terminated this employee, how productive do I expect them to be over the next 2 weeks or 3 weeks? If that's your feeling, you can have the employee leave immediately and then pay them as though they'd worked. But it's really important to realize that if you do pay someone in lieu of that notice period, that they are paid actually as though they've worked. So if they're a full-timer or a part-timer, that they receive annual leave on top of that they receive any long service leave if that's relevant, and that they receive superannuation for that time as well. That all is accrued as though they had actually worked. In terms of the notice that the employee has to provide you, that will come from the award or the agreement. So always check on that. That will be, generally it's the same. Generally it mirrors what the employer has to provide. Sometimes it does vary though, sometimes it's a bit less. So always check on that. Also what I should point out is that with that table that I just showed you, that is for full-time and part-time employees. With a casual employee, it's a lot less strict. It depends on what the award says, but generally it can be anything as much as an hour, or a shift, or in some cases a moment's notice. Literally that is what the legislation says, at a moment's notice. All right, well that's basically the legal side of things covered. Now I'm going to talk a little bit about performance management and why we think it's a really important thing to do. Just to define what we consider performance management, this is, I guess, a formal set of meetings that you would have with an employee to make sure that you have a very clear understanding of what the expectations and the skills and the behaviors that you expect from an employee are. We think that it promotes a positive and collaborative approach to the employment relationship. I think no one likes being told off. No one likes things to be reactive and only happen when things are going wrong. If there is a culture, I suppose, of regular meetings and regular discussions about the employment relationship in terms of how things are going, how you feel the employee is going, how the employee feels that they're going, and how that they feel you're going, that can promote a collaborative approach to the employment relationship and make it a lot less likely that a dispute will arise. Also, we definitely recommend that you keep a note of all these meetings and that you have a written record of any kind of meetings that you have. Another reason for this, at a purely practical level, say you have these meetings about an issue that you have with the employee. You have these regularly, you give them a time frame to improve, and you make sure that they are clear on what they have to do. If nothing else, the performance management process will go a long way to fulfilling your procedural fairness requirement. It will provide a written record that you gave the employee a chance to improve, that they knew what the issue was, and that they knew that eventually if they couldn't sort it out, they may be terminated for that. So if nothing else, performance management will help you meet your requirements under the law. So that basically covers it for me today. Just to reiterate, we've gone through unfair dismissal. We've gone through what a fair and valid reason is to terminate someone. We've gone through the prohibited reasons to terminate someone, the discriminatory areas that you cannot use as a reason to terminate someone. We've looked a bit about time frames and the record keeping process that you should keep in terms of terminating someone. And we've also looked at who cannot make an unfair dismissal claim. If you've got any queries about any of this, please do feel free to email Westlink at rdl.wa.gov.au. Any queries that you have about termination, dismissal, or your requirements as an employer, you can email there and I will do my absolute best to help you out with that. If you don't wish to email me directly, you can call WageLine and you can do it confidentially and anonymously. So WageLine is a free, confidential and unbiased service, and any information that you require about the legal requirements of terminating someone, you can contact them and get some information about that. Once again, I have to point out that this is a very general overview only, and you should always seek specific professional advice before acting or not acting on the information in this presentation. So as I say, if you've got any queries about that or any areas of employment law, please do feel free to email those to westlink at rdl.wa.gov.au or to call WageLine for a confidential information in on those areas. Thank you very much, guys.